if Indian courts are actually taking an extreme approach. There was a time where, before Balco, when the approach was extremely interventionist. Almost every 34 there would be a notice, and many awards were being set aside, and that of course had put us behind many jurisdictions. We were not a popular jurisdictions abroad. Every conference, international conference, would have India as a focus of an example how not to conduct arbitrations, and how not to how the court should not behave. But has that been taken too personally by Indian courts? I think now we are in a zone where other extreme approach is being taken, where just to be international arbitration friendly, the Indian courts are taking a stand where they just do not want to look at 34th. The approach is to dismiss it unless the court's conscience is shocked. I mean, that's fine. The grounds are limited, the grounds are confined, but we must also see that are we in sync with the appointment of arbitrator procedure? Because ultimately, whether Perkins has come in, whether other developments have taken place, there are still many contracts and there are still many cities in the country where you may not be able to find that paragon arbitrator. And ultimately, with a slightly wrong choice of arbitrator, or a choice of arbitrator who ultimately will deliver an award which otherwise is not fair and just and equitable, but just because we have such narrow scope in 34, the courts are not willing to look at it at all, so that they are considered arbitration friendly. Is this an extreme approach, or do you think this is actually an antidote which is needed to set out the discipline, and the courts are actually conscious of the fact that even if they're taking an extreme approach, it is required and it is the need of the hour?
See, Mr. Garg, I would think that whenever there is a kind of a shift, a paradigm shift in the prevalent law, because it's a contrast, it becomes more apparent. You feel that there is a kind of probably unjustifiable denial of interference. So that I do see your point. But what I'm trying to tell you is that when there's a paradigm shift in law, it definitely causes some concern in all quarters. Now see kindly one thing straight away. Firstly, international criticism that Indian courts are interfering too much. Okay. Secondly, there is a legislative amendment bringing out various factors, including the amendment of 34 grounds, and then you have the two restrictions. Third is that you yourself feel that, look, there is a little abuse of process of arbitration, and the purpose of arbitration is being defeated. Because Mr. Garg, I'm sure that you do know that there are a lot of arbitration cases where parties are not behaving the way they are expected to behave. So all this to meet out, you try to be more stringent. So you will see then it will emerge into a balanced state. So you had the one limit, one extreme. Now you may be nearing the other extreme. So gradually you will build up a pyramid, and the top will come where you will have a very balanced approach, and you will not feel that the courts are not interfering where it is required and are denying interference where it should not. So it will be a balanced approach, which automatically, it's a human process. Human mind process is such that it attains to, it's like, getting too fat, getting too thin. So every mind wants, so that's it.